appeared at the site. It's loading now. Okay, now we are live, bringing you our topics on debt recovery. So can I confirm it is live now?
Yes,
the panel, will you be able to see? Yeah, we can, right, Mr. Paul? Okay. Right.
Yes.
Good afternoon. Good afternoon, everyone. Happy that you be able to join us for today's topic. It is pertaining to pretty crucial topics on debt recovery. Okay. So this debt recovery basically, in a simple sense, is how do you commence legal action during the lockdown period, during the MCO and force period. So many people probably have some claims against somebody. The plaintiff wanted to sue. How do we sue? So it put it in the most simple sense. And we are fortunate today. We have a few lawyers, which is very active in the litigation industry. First, we want to introduce Dennis from Jason Co & Co. Perhaps Dennis can say hi to everyone.
Yes. Good day, everyone.
Yeah. Okay. So Dennis also focusing on litigation himself. Also frequently go to court and attending several different matters. Okay. Next we have Mr. Paul from Paul and Partners. Yeah.
Hi,
Paul, how are you today?
Good. I hope everyone's well, huh?
Yeah.
Yes.
Okay. Thanks, Paul. Okay. Last but not least, Satya Lee and Co. Yeah. So he is also major in litigation. So Satya, how are you today?
I'm fine, Jason. Thank you. And how's everyone doing? Duduk rumah diam-diam.
Yeah. We obey the law, especially the lawyer, in full comply of the law itself, and we lock ourselves up. So you can see all the lawyers are within the four walls now at the moment. But of course, despite that, we are not being confined to this place. We're trying our best to reach out during this period. I think everyone should have legal access. That's why we are thinking that all of us get together to share out some of the legal knowledge to everyone. Hopefully, by end of the sessions, it is helpful to everyone. At least get some basic idea of how do we approach of issues at hand. Now, because of the current situations of COVID-19, it has been prolonged ever since the 18th of March, which is until now. As far as the record shows, we will continue to lock up until 12th of May, and we do not know how the sequence go. It very much depends on the numbers and everyone compliance of the MCO. If there is an improvement, that will be great because we will back to work on 13. Otherwise, it will be prolonged, as mentioned by the Prime Minister. So what next is we take the initiative to introduce to everyone here during the lockdown period, in particularly MCO period, how are you going to commence the action? So I will just start off with some basic scenario. But before we go to the scenario, perhaps we have to do some housekeeping. Some house rule is every one of us the panel speaker will then share some their point of view pertaining to the entire legal actions and during the MCO period, but that will take up approximately about 30 minutes to 45 minutes. Thereafter, we will open up for questions. And if you can see there are chat, you can actually make a comment from the Facebook page. You can put up the questions there. We will then track your questions and I will read it out to everyone. Then in sequence that you all can take up the answer. One by one to answer it. That is the basic house rule. So that would be part one, sharing, part two, questions. Pretty simple. Now, so come back to this, the issues. Straight away, go to this debt recovery during the MCO. So scenario is that very basic stuff. Good soul deliver. It is not uncommon. It is pretty common. Even before the MCO, everyone is commencing legal action for recovery of some debts, some outstanding due. But the tricky part is, what is going to happen now is during the MCO, how can we, take up an action while we all locked up at home? Yeah, can we actually sue somebody during this period? How is lawyer firm is not open? All right, as far as I know, law firms are not open. You see, all the lawyers here are locked up within 4 walls, and the court are not open. As far as I know, but maybe you can enlighten us what court are open, what type of court is open. So if somebody really want to recover some money by way of a legal means, so how do we go about this? So I'll get the ball rolling by asking Dennis to share with us. So say a plaintiff wanted to sue. So how do we take on from there?
Okay, thank you. Good evening, everyone. First and foremost, before we speak about how a plaintiff can commence an action, whether is it a civil action in court, we should look at two perspectives, because in a debt recovery action, there are two perspectives, which is from the claimant perspective and the defendant perspective. And fortunately for us today, we have two honorable guests with us, Mr. Satya and Mr. Paul, which is going to dissect on the perspective from either the claimant or either from the defendant.
Yes. Okay, so Dennis, so how do one practically sue during this time? Because now we are looking into a scenario that perhaps everyone can chip in a bit on your input. Just yeah.
Okay, all right. First and foremost, during this MCO period, the court's e-filing system proceed as usual. So basically, for the claimants out there, they can still send out the letters of demand, which has a 14-day lapse. The manner of sending out the letter of demand can be via email or can be via AR register post. But the priority here is that the letter of demand has to be received by the opposite party. So once the 14 days has lapsed and there's no reply, then we'll proceed with a civil action, which is via a writ summons. You can do that by filing in the courts. But before we proceed to that, also we will talk about the quantum here. Because magistrate court, there's a quantum there which is not exceed 100,000, and then you have the session court, which is quantum should not exceed 1 million. All right.
Okay. All right. So that you goes that now I think we have some input that if a plaintiff have a very strong cause of action and intended to sue, then perhaps now the answer is they can actually commence an action. You can look for your lawyers to proceed. Now, anyone want to share about the defendant perspective? While we are talking, we also look at the flip of the coin and see how does the defendant going to react when they got a letter of demand. Perhaps Satya or Paul can share with us in the defendant perspective.
If I just can chip in a bit, all depends on the case by case, I would say. If you receive a letter of demand, your client will, of course, will want to first thing try to look for a lawyer. So even he looks for a lawyer, he needs to provide all the information, details, documents, everything. He may have it with him in the house or he may have it in the office. So with this MCO, it will also be very difficult for them to provide you complete instruction. I will say as a lawyer, if to safeguard your client, I will put up a holding letter, maybe to inform the lawyer that you are representing your client and you reply after when your client is able to give you complete instruction. Is it?
I mean, just add on, Jason, for what to what Dennis and Paul said. For Dennis, because just to add on, I mean, the monetary jurisdiction is there, but sometimes it's just a case-to-case basis as well. If the amount might be 50,000, but you have to file in sessions court because there's a certain powers that only conferred to sessions court, so it can be that size scenario as well. While for the pause situation, there's of course you can send a holding letter by the solicitors. If the particular company or individual unable to get their respective lawyer or what, they can send their own letter also saying that this during MCO, kindly give us an extension of time to reply. I mean, the particular individual or company can reply as such letter because I mean the such situation is at this juncture.
Yes, yeah. So I think hope it benefit everyone here when we talk about in a defendant perspective. It is not, remember, the letter of demand always come with a due date, so do not ignore the letter of demand. Quickly find your lawyers to respond into that letter. Like what Mr. Paul said, that, probably will ask for extension of time because it's very difficult to move around or even contact the client, get instruction, and so on and so forth. So I think this is a very good good insight for all the defendants and the defendant perspective in defending a case. Now, I think Dennis also highlight about monetary jurisdiction of the court. Now, there are probably a lot of people who've been asking. Firstly, we are not sure there are how many types of courts in Malaysia. Generally, I mean, then why are we sometimes end up in magistrate and sometimes in high court? Yeah, so anyone can actually share with us. I think Dennis have touched on that. Maybe Dennis can further elaborate a little bit on this, on monetary jurisdiction. So let's say, I'm just bringing an example. If you get a letter of demand of 500,000 claims, so where are we heading to? Let's say 500,000.
Jason, for 500,000, the demand will be in Sessions Court. Because as I just elaborate more further from what Dennis have elaborate earlier, usually we got three courts, the trial courts, which is known as trial courts. The magistrate courts, which the jurisdiction is up to 100,000. Then while for the Sessions Court is up to below 1,999,999. Then above 1 million onwards is in the High Court. But the size situation sometimes might be a 500,000, but it can be filed in High Court as well, because it might be a different nature of case. Or like you explained earlier, it might be a 50,000 or 60,000. But just say example 60,000 magistrate, yes, of course go magistrate court, but just say they're required to file an injunction. Just an example. It goes case to case basis. If injunction, of course the magistrate court do not have a power. So therefore, it goes to the Sessions Court.
Yeah. So I think most of the time it will be depends on the case to case basis, and also the subject matter and what are we looking at? What are the remedies that we are looking at in totality? I guess. Now, I think now everyone is very clear that I mean, the straight answer is now you can actually proceed because the e-filing system is in place. The lawyers are work from home, so it does not affect everyone to have a rights to claim at this time. So that is clear. And monetary jurisdiction also we are quite clear. So now we know why do we go to this court and not that court, and that is also clear. So now next. I think the general public out there wanted to know, I mean, in the plaintiff perspective, if I've ever wanted to sue, I want to recover my money as fast as possible, simply because I'm going to have a burden to carry. The 6-month deferment is going to up in October. When I'm back to work on the 13th, I will have salary to pay and overhead to carry. So, but then, at that time, I realized there's a lot of outstanding amount, that unclaimed amount from my office. So I want to know how fast I can claim back the money by commencing the legal action. So we are talking about time period now. So how fast? Yeah. So any one of you can actually pick it up if you think you have something to share. I mean, in terms of timeline and all.
All right. First and foremost, for that required proceeding, normally, I believe the folks out there will heard of this application. What I call it, the application for summary judgment. Summary judgment is where the facts are. It's where the defendant has no merits in the defense. Basically, the case is a clear-cut case. But as the two other speakers, Mr. Satya and Mr. Paul, has pointed out, cases in Malaysia is what we call it a case-to-case basis, because there are many other resetting factors that we cannot predict that might come into place. Let's say we have this application for judicial management might come in also, which might disrupt the entire proceeding of the case itself, and which might that's why the time period is, we can't give a certain time period. Yeah, thank you.
Yeah. How about others? Input? Any other input? As far as time is concerned?
I would say,
just like Sorry.
Sorry.
Mr. Paul? Yeah.
I would say also like, yeah, correct. I would say go back to case by case basis. If it's straightforward, if there's no contested matter, it may be fast. But also depends on the now the current MCO depends on the fixing of hearing of the matter. But it can be done video conferencing now, if I'm not mistaken. Right.
Yeah, because
see.
I just add on to Paul, what Mr. Paul and Mr. Dennis have informed.
Satya,
It's
you want to add
just
on? Yeah.
Yeah. I'm adding. It's just a case-to-case basis because sometimes you can get a judgment at early stage where they are not contesting at it, or if your case are solved you're stolen.
I think the line is bad, right?
You can apply for summary. Okay. Okay. Now it's clearer. So if
Right.
we can apply for summary judgment, if no means if you're contested, then you have to go for a trial. So it's a case-to-case basis. And how strong is your case based on your evidence being furnished to your lawyer? Yeah, that's all.
Yeah.
Listen.
So I think the time is very subjective. As in terms of timeline, it's very subjective. If it is a highly disputed issue arise among the parties, then perhaps it will be a longer time. We will measure in that manner. If a straightforward goods sold deliver, invoice are in order, everything is in order, I think the timeline for recovery is pretty fast. Now that would be able to assist some of the company. They will eventually, when the MCO is lifted, when they back to office and they see number of invoices are uncollected amount, so they basically have an idea how fast they can recover. Now, of course, keeping a record is very important in assisting your lawyer for a matter, for a litigation matter. So now, if I'm moving on to the next questions, most people would ask is, now because of the MCO, everyone is pretty constrained in terms of financial standing of each company. Individual, be it individual as sole proprietor or a company to that extent, I would rather concern of your legal fees. How much do I have to spend in order to collect my $millions invoice? Or if I have an outstanding bill of probably the guy owing me about 20,000, so how much do I have to actually engage a solicitor to act for me to sue for recovery? Because I think I have to go to this very critical point of this. Also being practical, there's no point of suing if I'm going to pay for a fees of 50 a million. I don't know how much is the fees, but perhaps I think you can enlighten us so that the general public out there will have this perspective. Look, I probably have to prepare certain amount of money, to gauge, to seek recovery of my debts, according to the invoice. So now we talk about general. I'm not referring to your charges, but in general, how do we ascertain these fees?
Okay, I'll start first. Jason?
Yeah.
Okay.
Yeah,
I
sure.
think
Mr. Paul,
it's all
go ahead.
go back to how you engage your lawyer. I think you need to discuss with your lawyer, negotiate on the fees, because it may be also very subjective. Your claim may be maybe 10,000, 20,000, is it? And depends on which court it falls to. And at the end of the day, how complex is your case? If it's straightforward matter, I believe your lawyer will acknowledge that and give you a reasonable price. But at the end of the day, I say it depends on two things: how complex is your case, and also how you negotiate with your lawyer. Maybe you can work something out with the lawyer itself.
Yes. How about others? Since everyone is practicing, right? So
Okay,
I think the viewer wanted to know. Yeah.
all right, if I may, first and foremost, before we talk about the fees itself, we have to look to the facts of the case. Like Mr. Jason earlier has pointed out, does you have a sufficient or clear-cut invoice? Is there any complication that might arise in the case? So all these tiny factors might affect the fee structure for the case itself. Thank you.
Yeah.
Just to add on to for what Mr. Paul and Mr. Dennis have informed. So it's just actually it's a very subjective and it's case to case basis. It's a depends. Actually, the lawyers will look how complexity and how complex is the case. Actually, that's actually determines the most of the legal fees.
Yeah.
I mean, back to you, Mr. Jason.
Correct. Yes, I think it is pretty fair. I think people out there will be also able to comprehend why is it so, because we assume that complexity will come with more work. If anybody who work longer hour, which is entitled for more remuneration, wages is higher in that sense. If it is less complex, probably will less work. So you're looking at that manner, how is it measured? So there will be no fixed cost for this. I know, unlike conveyancing practice where it has been codified in terms of the fee structure, but in litigation, it is really depends on case to case basis. Okay, so now we have also covered the cost, time, cost. I think it's beneficial to people out there. Now you have your own budget, in terms of commencing legal action. Now, we come to the enforcement, because I think the last issue that we're going to address now, it is pretty crucial, because everyone wanted to know, how do I get back my money constructively? I mean, in terms of practically. Now, you can take an action. I have a strong case and you win the case. So probably in the legal sense is we are looking at enforcement of judgment in this area. So to answer the general public out there, how do I physically, I know you can sue, I know you won the case, but what if they don't pay, so what next then? So we are going into the enforcement. Yeah.
If I may, Jason, for the public actually need to know that initiating a civil suit, litigation suit is the first step. It's not upon you getting a judgment, monetary judgment, it's not the end that saying that parties will pay. There's some parties could be individual. I mean, when you sue, it could be an individual, could be a company. So when you sue, maybe some of them might pay the moment you get a civil court judgment. But in a practical, most of them, they won't pay. So if they don't pay, people will be thinking, is it the end of the world that I can't get recover my money or whatever? Or I only have a paper judgment. So there's a few type of enforcement. Actually, this is a second step, which is known as execution or enforcement. So actually, the most of the lawyers that go like a case to case basis, they say, okay, our fees for the getting a judgment as a such. If going for enforcement, it'll be as such. Okay, that's also, it depends on case to case basis. There's a few type of enforcement that can go. If individual, most of it, the individual that go for bankruptcy. But now, since the bankruptcy, the amount has been increased for 50,000, so it depends. If lower than 50,000, is it an individual or company that can go garnishi? They can go for seizure of sales, and there's other types and other. But these are quite common and quite frequently used by most of the litigants. But for the companies, usually they'll go for winding up. Winding up is very famous for, it can be a company, usually bankruptcy for individuals and winding up mostly for the companies. Winding up is quite very famous mode of enforcement. You see, recently, the last time, they have enforced saying that the moment you have delivered the notice, within 21 days, they have to reply, failing which they can file a petition, winding up petition. But winding up petition, the amount is 10,000. But now, because of due to MCO, the government have given some consideration and some leeway for all this debt people to pay their sum. Because so now they have it's been gazetted in Parliament. That's where from 18 March onwards, since the day MCO was uplifted. So it's where it says that they have 6 months to reply the notice compared to 21 days. And after 6 months, if they don't pay, the amount also has been increased from 10,000 to 50,000. So by looking this way, the government has given much consideration, a leeway for these people to settle the amount. Because once the company has been wound up, it's wound up. So it's very difficult. Once you go to insolvency department, DGI, then after that they wound up and then after that I can go for liquidation and such. So usually I think with new amendments, they're giving a leeway and giving a better options for people to have a time limit for them to pay. But the public must bear with us that although the amount is a small amount, but this execution for winding up and bankruptcy only can be applied in ICOT. Back to you, Jason.
All right. Yeah. Okay, so I think like Satya has told us, in general, there are plenty of avenue to recover your monetary sum. We did told you about some of the mechanism. Well, it's a bit technical. Like for example, garnishing proceeding, or to the extent of sometimes you heard Satya told you about we have judgment debtor summons and so on and so forth, winding up proceeding and so on and so forth. But those are some of the way that bankruptcy proceeding as well, winding up bankruptcy for individual. So these are all the probably some of the way is suitable for your case. Some are better way. It is meant for your case. So it is case to case basis as well. So we can't tell that there is no one blanket rule that this is definitely a good way to recover. It's really very much depends on the subject matter itself. Okay, so
right. Sorry if I may add on for Mr. Satya winding up. I just want to highlight attention to the I think the 7 initiatives that introduced by the SSM lately, which they increased the threshold for the winding up from 10,000 to 50,000 ringgit. And also the Section 45 notice was the duration was extended from 14 days to 6 months, is it? Not mistaken.
Yeah, 6 months.
All right, thank you.
21 days to 6 months. Yeah. So in other words, in very short summary, basically if anybody who, winding up, there are many patterns of winding up. They can be members, voluntary winding up. There can be compulsory winding up where people, back to the old days is 208 notice and now it's 466 notices. And now it changed again in gathered for this MCO period. So you probably will have a 6 month times to pay. That is a 6 month notice that telling you that before that it is 21 days. Failing to pay means that you have committed, this unable to pay insolvent stage of the company. So like Satya said, there's a leeway, there's a buffer time for you to recover in a way. Of course, we will not go into the company rescue mechanism or individual, in response of bankruptcy, because that wasn't the topics today. Because the topics today is more on debt recovery in terms of the plaintiff side, not the defendant side. So the plaintiff side, I think I can straight away go to the Q&A. So the half an hour is up. So we're entering the part 2, second sessions of the day. I will then look at the columns at the side and see anybody who asks us any questions or not. I think we have one question. The question is, can anyone or company be sued for bankruptcy during the MCO? So I believe a bankruptcy is directed to individual and winding up is directed to the company. So that is the questions here. And perhaps any one of you can actually take up to answer it. Not sure the panel have here my questions.
I can share my view. I think I think if the lawyer is able to work at home, I think they can issue notice. They could issue a notice out to them, letters, so can be issued out. That depends also on the amount, the sum. The company for winding up is 50,000 now. Bankruptcy also is also 50,000. So it depends on the amount whether they reach that threshold. And first of all, I think notice they can start this process to issue the letter out. That is what my opinion is.
Yeah. So I think this during this MCO, I think we repeated it again that anybody who have debts outstanding due to you, it is a genuine claims. You may then thinking of probably will start some action. You may not wanted to wait until the MCO is lifted because we never know when is it going to lift. That doesn't jeopardize you from taking action because now we have lawyers to tell us that we can actually sue. So the sequence is a letter of demand will take up several days, a week or so, and perhaps they will then get a lawyer to respond to you. So that will take up some time. Well, during this MCO, you got the benefit of clearing off all this timeline until you seriously file an action in court. Yeah. So if other than, I think people, okay, let's say, is there any alternative resolution between the parties rather than just sue? Lawyers, being lawyers, we wanted to sue, but then do you have any other solution, apart from going to court? So based on your practice experience.
Sorry, if I may, I just want to bring a highlight to this certain issue. All right, throughout the court proceeding, there might be one instance where the magistrate might direct the party for session, what we call a mediation session. Mediation session, I think is proved to be quite crucial in a way that it managed to save time and cost in the event that both parties managed to reach out of settlement. Thank you.
Okay, thank you. So Dennis, thank you. So how about others? Have any view on this?
Without going a legal proceeding, there's sometimes parties can settle the moment the letter of demand has been signed. Sometimes the moment a legal firm sends a letter of demand, he might engage the other side, the defendant might engage a lawyer, or he might write himself to this particular lawyer saying that I'm agree for settlement. Let's propose some lesser sum, paid installment, for example. So then there might be a few letters will be issued between the defendant and the plaintiff, between the suing party and being sued. So it can be then it might be such a way as well. Then based on that, the parties might enter into a settlement agreement sometimes. Settlement agreement based on a trust, because the letters based on the letter of demand saying that we agreed for this amount, but there's no surety that the plaintiff will get the whatever agreed sum by the so-called defendant. So they might enter to a settlement agreement because it's just to protect the interest of the plaintiff, because there's no any form of protection for the plaintiff saying that this defendant will pay the whatever agreed sum. So they might enter into a settlement agreement and parties will sign. If the defendant so-called breached the terms and condition of the settlement agreement, then they might, if they fail, then they might fail. Plaintiff will file a suit against this defendant for breaching the terms and condition of the settlement agreement.
Yes. All right.
One of example.
Another thing, just to add on, probably my view also is that maybe when you start to issue out a letter of demand, you will probably try to engage them to talk to you, especially the defendant. You can put in the interest accrued until today on the principal amount. Then when they start to negotiate with you or talk to you, you can say, maybe you settle the principal amount, then I will forego the interest. But of course, commercial decisions at your hand, client's hand. Maybe that's another alternative rather than to go to court and claim. You see, another alternative, I would say.
Yeah, thank you, Mr. Paul. So yeah, I think apart from commencing actions, I think there's also a alternative resolution in the matter. I think all panel have clearly stated, it is always an alternative to settle a dispute. So this is also another avenue that probably public can look into, resolve without going to court. I think nowadays court have this tendency that would want the party to resolve via mediation, what Mr. Dennis told us, that eventually, even though if you file an action, the court will always encourage parties to mediate and resolve the matter out of court. Yeah, so I think that there's a trend now at the moment. Okay, before we move on, I think I saw some questions here. So the questions goes like this: can I declare myself bankrupt to court without the presence of lawyers or anybody? Yeah, so it is like self-declared bankruptcy kind of questions. So what do you think? Can I declare myself bankrupt? Yeah.
Okay.
So anyone can take up this question. Yeah. Yeah, Mr. Satya.
Okay, I just briefly then please. I think Mr. Paul and Mr. Dennis can add on to that. Of
Alright.
course.
Yeah.
I mean, can I declare myself bankrupt to court without the presence of lawyer? Of course you can. This is more than happily the suing party will be more than happy to make you a bankrupt. but they must understand that once they're bankrupt, their position is different. Once they declare bankrupt, the DGI is in control of you. So you can't take a bank loan, you can't apply for credit card. I mean, literally, you are, when it's a nutshell, when someone is bankrupt, you can't do something legal like how others do. If you want to travel, you have to get permission from the DGI. Sometimes you have to get a clearance from the immigration. There's so much of hassle. And if you are bankrupt, then of course just say the said amount is 50,000 you're suing, and you declare saying that I'm bankrupt. They'll make you a bankrupt, but there might be a DGI. You are entitled to pay a certain amount to the DGI, so that the DGI, a particular person can go and talk to the DGI, say that this amount, I'm only able to pay this amount every month. So from that, they'll make a payment. So sooner, you'll be out from the bankrupt.
Okay. So how about others, panel? Yeah, thank you.
If I may, I just want to add on to what Mr. Satya has clarified to us. All right, this adapter itself can declare itself as a bankrupt, which is we are filing of a debtor's petition. But just like Mr. Satya has pointed out, is that this is a very serious matter, because once a debtor files the petition cannot be withdrawn without the leave of the court. Okay, I think most of the folks wonder why would a debtor self-declare himself as a bankrupt. The purpose is only one, which is to protect himself from the creditor's claim. Because this debtor, I think he's well aware that he cannot satisfy any creditor's claim out there. Hence, the only means to protect himself is via the filing of this debtor petition. Right, thank you.
Yeah. Yeah, thank you, Mr. Dennis. Mr. Paul, you want to say something?
I just one. I think I will just add on one. I think Satya and Dennis covered all of it. I think at the end of the day, even though you have filed in a declare bankrupt, you need to still make arrangement with the on how you want to settle the outstanding amount. So at the end of the day, you still need to come up with the arrangement with them. There are restrictions as well if you are once you are declared bankrupt, you see. So that you need to have foresight of that to be prepared, you see.
Yes. Thank you, Mr. Paul. I think for the general public out there, if you might want to think twice or consider should you or should you not head to the bankruptcy, pertaining to the self-bankrupt, because there are plenty of alternatives out there. As far as the recent amendment law is concerned, there are some arrangement scheme of payment, and also AKPK are in place that could assist. It really depends on what are the debts that you are looking at. Was it a secured debts or the unsecured debts kind of thing? I would suggest, before you end the games, I would advise you to look for your lawyers, to seek for legal advice on, what are the what are the resolution, what are the remedies that I have. I couldn't secure an income at the moment, and I have this bill to pay. So how do I'm going to juggle this? Now, so I would suggest that you seek consult for lawyers on this before you end the games. Declare yourself a bankrupt. Yeah. So okay. So come back to the issues about debt recovery during the MCO. We did talk about commencing action. Now everyone is very clear. Now we can actually start suing somebody if our documents are in order. Probably just a call away with your lawyers and start sending emails and so on. Now, I think the clients want also, or maybe general public also wanted to know, since everyone is locked up at home, if the court have give you a date, so I presume you can do e-filing. I presume that the court will extract a date for you to attend. So how do lawyers attend court now if the court is not open? And we tell ourselves we cannot go back to our office. So how? So I think the public wanted to know how do you going to attend court if you are locked up here?
I think I'll probably start first, Jason. Maybe.
Yeah, sure. Mr. Paul, yes, go ahead.
I believe, even though you file any papers in court, start your cause matter, the court will take knowledge on this MCO. The hearing date, I will expect practically they will fix after this end of MCO period. If they do not fix a date after the end of MCO period, they'll give a date, but nowadays lawyers can go online to the court system website platform to have a case management between the court and the lawyers, and to be updated on the matter. So still it can be done for timing for case management purposes through court platform.
Understand.
And video conferencing as well is another
thank you.
option.
Yeah, thank you, Mr. Paul. I think it is also in line with what we have also witnessed on the recent, the milestone that we have achieved in terms of the judiciary. You can see, Court of Appeal have initiated the hearing, online. If I remember correctly, there's about 32,000 people watching the hearing online. So I think that is an example of how the court, commence themselves, move the case during the MCO period. So like what Mr. Paul said, I think that also answered. There will be no backlog of cases. So as far as the case is concerned, the court still fix a date. The lawyers don't go to court, but they attend like a Zoom meeting or the platform in the Kehakiman website, whereby they can see each other. Or maybe I think for e-review purposes, it is more like a tapping, message. So court can still give directive via the filing papers, filing common bundle, and so on and so forth. That can be done via this e-review. I believe all of us, practitioners, has been going through this process as well. Yeah. Okay, so if I proceed with the Q&A, I think that's about it for the Q&A today. Moving on, because we almost close to the end, and perhaps I will just leave a few minutes for all of you to, give us some insight or probably your last word before we end our sessions. Let's start off with Dennis. Mr. Dennis, you tell what you want to say before we end. Yeah.
All right, folks out there, this is quite a crucial time. So my only advice is that I hope you guys will manage your personal finance properly, and take note of all your expenditure. All right, thank you.
Thank you, Mr. Dennis. Yeah, I think that is very important advice. During this lockdown, everyone has learned to spend wisely and don't simply, spend. Okay, next, Mr. Paul, you want to tell us anything before we end?
I hope that everyone will stay safe and healthy. Just heed to what the government's directive is to stay at home. Just and try to eat healthy as well.
Yeah. Thank you, Mr. Paul. I think it's very important that everyone stay at home. The last sessions that we have, we talk about this arrest and remand during the MCO period. I think the statistic did show there's about among 13,000 of them has been arrested. That will be either fined or put into jail. So I think the strict compliance of the MCO is very important. So yeah, very well, Mr. Paul, tell us that. And how about Mr. Satya?
Everyone out there, just stay safe and let's battle together to battle this COVID-19 together. The only one thing I want to say is that duduk rumah diam-diam. Please go out if necessary.
Yeah, these are your jargon kata. I think the last round you say the same thing as well, right? Maintaining. Yeah. Thank you, Satya. Thank you, Mr. Paul. Thank you, Mr. Dennis.
Thank you.
Time with us. Yeah, and give us an insight on debt recovery during the MCO. This is because our best effort that what the lawyers can do during this time is to reach out. I think all of us here, I believe everyone should have a equal legal access to all levels of society. And that hence we are here to share with you some of the legal knowledge. I think the panel are also looking to look forward for another topics, which is another hot topics coming soon, probably I think on Sunday. We will decide on the several topics that people wanted to hear. We will give some input, insight, and hopefully it's benefit to everyone from watching us. You can also reach us from the respective law firm Facebook link. I think Satya Lee and Co. They have the Facebook link online. If you have noticed our poster, it is there. You can check out the Facebook link. Mr. Paul and Partners also he have his Facebook link there. Jason Coin and Co. also we have our Facebook link there as well. So if you have anything, you can ask us anything from this this platform. From the Facebook channel, I think Facebook have provided you ample avenue to talk to us, from email to WhatsApp and so on and so forth. But before we end, we wanted to thank everyone for attending, and I hope everyone will stay safe at home and stay calm. And we hope for the best for the Malaysia. All right. Okay. Thanks everyone. We'll leave it for now. Catch up again. Everyone. Thanks. Bye. Yeah.
Thank you, everyone.
Yes.
Bye.
Bye. Yeah.